Well, good afternoon, everybody. As people are arriving, a few familiar faces here. We have an enormous number of people signed up for our afternoon webinar today, Friday, 16th of May, where we're having a conversation with the mediator. And you may notice I have a guest with me who is going to say hello, Arabella Tresilian.
Hi there, Mike. Lovely to be here. Thanks for having me.
You're very welcome. So, Arabella is one of our mediators and trainers. We're going to hear from Arabella in a second. I'm just waiting for people to get in. It always takes a half a minute or so for people to arrive and get their position. Um, so there we are. So the numbers are still clocking up. So this is one of our series of afternoon webinars. This was started last year in our 25th anniversary, having conversations with a mediator. So we have people from our own panel and people from the world of mediation who we've invited on to chat about their work and their background and talk about really the real world application of mediation. We talk a lot about training and about becoming a mediator on these webinars. But this series of webinars, the conversations with the mediator, are more about mediators who are quite well established, who are out there in the many multifaceted world of mediation, doing different things with the skills, techniques, and theory of mediation. And Arabella is one such. So very nice of you to join us today, Arabella. Perhaps we might start. Tell us a little bit about your own background, please.
Thanks, Mike. I'm a mediator of getting on for 10 years now. I trained in 2016, initially in community mediation with what was then Bristol Mediation, now Resolve West. And I'd thought for many years that I would love to become a mediator. And it was really doing community mediation that allowed me to fall in love with it. And after that, I trained more formally the following year and sort of took off from there, doing workplace and employment, community, and also civil. And I really moved pretty quickly into health and social care as my main arena, and that probably speaks to my original background and my area of of passion.
Okay, for those who'd be less aware, Arabella, perhaps talk a little bit about mediation in health and social care and how it gets used, and that's sort of the case for mediation really in health and social care.
Yeah, by all means. So, I mean, I came to this really as a carer of a family member and a patient myself, but also I'd been working within health and social care organizations in the public sector. And all along the way, I'd seen this difficulty that we can experience, whether service user or carer or professional, around decision making and around communication and bridge building when things are
Yep.
really challenging. So the work I do now sits in various arenas. I do work in social care, which would mainly be court of protection work. And that's largely where there's a disagreement around the care, residence, treatment of a person who lacks capacity to make certain decisions around their own life and living. And often in those instances, there's been a real breakdown of relationship between family members, care provider, local authority, social workers. So mediation helps take those legal disputes away from the court proceedings. There's space for relationship building, narrowing issues, making agreements around care and treatment, for example. So that's one area, that's the sort of social care. Then a second area would be around medical disputes. And those are some of the ones that are the most poignant. Those can be the ones around withdrawal of life-sustaining treatment. And often those are either on the way to court or proceedings have already begun. And that's where we're using mediation alongside clinical ethics committees and second opinions to help broker conversation and understanding so that the parties can make decisions about care and treatment themselves without recourse to court.
Sure.
And then a third area would be workplace mediation within health and social care. So colleague disputes, colleagues falling out under immense pressure of working in, for example, the NHS, or perhaps people with disabilities within the workplace who need support. Mediation can be a really great arena for sort of recalibrating, making space to talk safely and privately about reasonable adjustments that might be needed. So those are just some examples of the ways in which mediation can create space for dialogue about some of the most important things.
Absolutely. And what in our own experience, last 26 years of training people within NHS trusts, the initial focus is often on staff disputes or colleague disputes, grievance type issues. But what we've had is then the trust comes back to us and says, hey, we could use this for complaints handling. Hey, we could use this for when people's behaviour has been inappropriate, where carers and relatives are coming into the hospital premises and the behaviour has gone through the series of steps and stages that a lot of trusts have. We could put mediation in there. We could have mediation in around probably the largest area of application that we've had is around best interest cases, particularly when it's a child where there's a decision to withdraw medical treatment and go to palliative care only, the high profile cases that we've done, which ultimately go to court. Mediation can get right in there and make a massive difference, particularly ensuring that everybody's voice is heard, ensuring that there's a dialogue and a sense of collaboration rather than just a decision where somebody gets what they want and somebody doesn't. The applications are enormous, aren't they, in this arena?
I think so. And I think, I have to say, I'm neither a lawyer nor a doctor. So, and you too, yeah. And that allows me to be, not representative of any of the professionals. I don't necessarily speak about my personal experience, but I definitely bring it there. And I think what can happen is that for families, they have so little experience of what happens when these matters go to court, that it feels as though going to court is going to be the fairest and most rational place for this conversation to be had.
Yeah.
Actually, the experience of families when they go to court to see a ruling around, for example, the withdrawal of life-sustaining treatment, is that it can be deeply traumatic. And in fact, for me, mediation, one of the values of mediation for medical disputes is to be able to have a safe space in which to talk about what will happen if things go to court.
Yeah. Yeah.
And because very often I find either families don't really know, they imagine that they'll get to represent their child themselves, and it can be a really real shock to them to understand that they won't be representing their child. But also I find that sometimes trusts come to mediation saying, we'd like mediation. And I say, what happens if we're not able to come into an agreement? They might say, well, then, we're ready to initiate court proceedings. And I'll say, is the family aware of that? And very respectfully, they'll say, no, we don't want to seem like we're threatening. But actually, I feel that families need to know what will happen if mediation or other forms of decision-making aren't effective. And also, there's nothing to stop a family and the trust bringing legal advisors to mediation. Mediation is not a non-legal arena. So many of my cases will have the solicitors, the barristers involved. And actually, that can be a very helpful experience for the family to be able to explore all of these issues in a facilitated space, but not before a judge, because we know mediation is a space in which only the agreements are only made if they're agreed by everyone there.
Sure thing. And they're not about rights and wrongs. And I think, as you allude to there, and with the medical mediation cases that we've had many of over the years, the parents often, when it's a child case, can misconstrue the purpose of the court hearing, and it can feel punitive. They'll hear it as a threat, even though it's not framed in that way by the trust. It's like, agree with us or we're taking you to court. Almost like, the parents will be dragged into court in order that the trust's expert opinion will be instantiated, or that the trust will be proven to be right and the parents proven to be wrong. And it's not that. It's very much not that. And yeah, the other thing that comes as a surprise to a lot of parents in these types of mediation situations where sometimes they go to court first and then try mediation, which I think is unfortunate. We ought to be thinking about it the other way around. But quite often the assumption is not shared by the court that the parent has the child's best interests at heart, and that's a difficult one for the parents to swallow sometimes, because parents will insist they have their child's best interests at heart, and inadvertently or otherwise they don't, which is a hard truth, but it's something that comes to the surface when we do end up in court, if mediation has either not been tried or if it's been tried and been unsuccessful. So I think weirdly, I think still a lot of education to do, isn't there, about what mediation's for in these cases and what it means when it does proceed to court ultimately.
I think you raise such important points, and there's very little really known or understood amongst the average parent around the zone of parental discretion in terms of the decision making that we do have.
Yeah.
And I think that is very difficult for healthcare professionals to talk about, because it can seem like it's a wrangle. And that's where mediation can be very helpful for, in a confidential space, creating some greater understanding. But the other thing is that that trust may come to a decision that treatment should be withdrawn, life-sustaining treatment should be withdrawn. But then the way that our system works is that the parents are asked to sign. They're asked to sign to that. And for many parents, and particularly, we've got a very diverse community, putting that signature on a piece of paper can feel like you are the one who is making that decision, or kind of, giving the go ahead. Stephanie Nimmo, in her beautiful book, Anything for My Child, talks about abandoning parents to their own autonomy. Like they've got their own, we can have as parents autonomy to decide, but yet we don't, because there is, the law around medical disputes is pretty extensive. So in terms of education for parents, I think not only are you dealing with having to become an expert in your child's condition, but also in this very complex and really unspoken about legal framework within which these very complex decisions take place.
And are not taken lightly. I've done some work with clinical ethics committees in various NHS trusts and sat in on the discussions with ethics committees. It's not something they treat lightly. And there's a whole science behind the ethics of this decision making and aspects that you described there, which I think is a fascinating thing that's not well known about the zone of parental discretion. And I'd encourage anybody to Google that. You'll find a couple of good papers on it actually around where the area in which the parents are entitled and advised to make decisions around the child's care, but there's a ceiling on it and there's a floor on it. There are things that are not within the gift of the parents to decide. Wonderfully interesting and expansive subject. If anybody who's on here today wants to chip in and ask a question or make a comment, if you pop your hand up, I'll keep an eye out for hands. There's a react button down the bottom of the screen with Zoom. You'll find a hand in there. Stick your hand up there, which you'll find in the react icon, and we'll come to you for your questions or comments. We'll be saving the presentation afterwards in case anybody who's not here today wants to see it as well. Talking about the expansiveness of this topic with medical mediation, Arabella, I understand you've been on your travels.
I have. I have. I'm incredibly fortunate. I was lucky enough to win or attain or be given a Churchill Fellowship last year, which means that I'm able to go and do some travels, to do some learning to bring back to the UK. So the subject of my my learning is, my project's called Dialogues About Dying, and I'm going out to learn about communication and conflict prevention in end of life and palliative care in other countries. So specifically, I've been to India for 3 weeks earlier this year. I'm going to Peru later in the summer, and I'm virtually visiting South Africa. And in each of these places, I'm meeting people who have experience, whether they're lawyers, doctors, palliative care consultants, nurses, family members, psychologists, of palliative care. And what I want to do is to understand how we can attain even greater cross-cultural competence in the way that we communicate about end-of-life care, in our own sphere.
Sure. Fantastic. I'm going to ask you more about that. I don't want to keep Aled waiting too long. Aled, you got your hand up for a question or comment. Would you like to unmute and chip in?
Yeah, I was just wondering, with the assisted dying bill coming through, would it be... I haven't had a chance to look at the white paper, and especially with the green paper on it as well. The fact is, what I would like to know is, would they have to enforce mediation first before actually taking it to the courts with anything because of the consent? Because you mentioned you do a deputyship and everything, especially if the patients are actually corpus mentis or they've got an adult learning disability.
Wow, what a question. It's a fantastic question. It's early days, isn't it, with the bill? It's had some amendments. I think it's being debated again today, isn't it? It went away and got quite a few amendments to it, including they got the sums wrong around the number of people that were going to be affected by the assisted dying bill. But using mediation where wouldn't be imposed, of course, it would need to be voluntary. But I wonder where family members are in disagreement. What would be your thoughts about that, Arabella?
I think you're right. It's early days. It's such an interesting question and topic. I'm really interested in the way that the assisted dying bill is about agency for the patient. So from my perspective, that's the lead aspect. Will there be family members distressed about the decision and distressed and in disagreement perhaps around the due diligence that was done for the go-ahead to be given perhaps for an instance of assisted dying? I imagine so. I don't know. I'm trying to take a very kind of watchful eye on this because this is such delicate space. Do I think that mediation is very well poised to help people have conversations that bring about understanding? Yes, I do. So maybe that's my main thought here, because there will always be the courts to make legal rulings. This is going to be a highly legally overseen process if it goes ahead. And I just keep coming back to mediation as being so powerful in creating understanding, and that helps people make decisions that feel more consensual when that is what is needed and appropriate. Mike?
And it begs so many questions about our ethical basis for these decisions, which is there in medical mediation. It's there in best interest cases. It's there particularly when there are children's cases where there's an argument for withdrawing medical treatment and going to palliative care only. A lot of times people will bring in some ethical basis for their decision, which might be a religious basis. It could be anything where their ethics come from. And we see them all the time, as we know. And I was just mentioning to Arabella earlier about this interesting decision this week from a court where there was a gentleman who's had a stroke. It's been in the newspaper the other day. And where he's non-verbal, sometimes conscious, but often not, and where the expert opinion is that they should remove the nasogastric feeding tube. They experimented with feeding him through an NG tube, and now they're saying we need to take it out. The last wish that the gentleman made before he became non-verbal and often unconscious was that his God would decide whether he lives or dies. And despite the expert opinion from the trust, the judge has made the decision that the feeding should continue and the experiment in the NG tube feeding should continue because that was the gentleman's last wish. Now, the wish was partly based, I wouldn't say wholly based, partly based on his sort of ethical basis, the ethical foundation, which is his religion. And these are always around. And I imagine, particularly, I mean, an issue around assisted dying, it really what shall we say, it really positions people in terms of their ethical stance. And I imagine there will be a call for mediation in some of these cases. So sorry, Alid, we rather took over there. I don't know if you had any thoughts of your own that you wanted to come back on, but do come back again to us if you would. It's such a fascinating topic. Here you are again. Did you have any thoughts about it yourself, Alid?
Yes, I did. The problem that you've got is as soon as it actually goes through the Parliament, then you will have another obstacle. It'll go through the Lords, and the bishops will no doubtly oppose it and everything. And I'm just, I don't wish for mediation to be mandatory, but it is highly advised before you do it, before you go into any court, because I have got a lot of ex-colleagues in the police as well, where they are suing the Metropolitan Police for unfair dismissals and this, that, and the other. And the backlog is just immense at the moment. Oh. And what they are trying to do with employment tribunals, it's a little bit different here in Wales, because people have a tendency here just to accept things and move on, as in compared to the rest of the country as a whole. And I was just thinking, because the government now is so insisting on the emphasis on mediation, and I do think more work is going to come in through that way with any bill that the government will be proposing, because the country cannot longer afford to go through the employment tribunals. The court costs are going through the roof.
Yeah.
And I know one court case, employment tribunal, which I would imagine would be the same if there's a backlog going to be in the medical stance. The next hearing will be for him 2028.
Ooh, that hurts. Yeah.
That hurts, and the government needs to wake up about stuff like that.
Okay, yeah, sure thing.
Legislation up, or try to get the mediators in, but they seem to be turning a blind eye towards that.
Brilliant. Thanks ever so much, Alid, for your contribution. Fantastic. And it also begs the very important question about whether we can ever mandate mediation when it's a voluntary process, which is another massive topic. Might do one on that one day. Thank you very much, Alid. And anybody else wants to chip in, you're very welcome. Pop your hand up. Meantime, Arabella, let me take you back to India. So tell me, since you're freshly back from there, what's a few takeaways then, would you say, particularly thinking about cultural aspects of these dialogues and how these dialogues have to take place? What would you say as a couple of takeaways from that trip?
The first major insight I got was around the way that the law is changing in India due to some amazing work by some legal professionals and medics. So it's now legal to have advanced medical directives. We have advanced decisions in England. It's all part of advanced care planning. So in other words, and I think this links back to what Alid was asking just now, this is about the conversations you have and the decisions you make way before you are at the end of your life. And it also links to the case that you just cited around what do we know about what this individual wanted. So the law now says in India that, and it'll take some time to roll out fully, that a person can note down what it is that they want to see for themselves at the end of life. And what we're talking here is really about documents that allow families and healthcare professionals not to extend life-sustaining treatment ad infinitum, which can be very burdensome for the patient. So this is about having dialogue. Oh, I've got some feedback. It's about having dialogues and around where people can make decisions in advance and really kind of state their perspective. And where this is really valuable in India is as follows. I arrived in India in Delhi and was staying in a homestay, and the owner of the homestay came and was very charming, very polite, very welcoming, and then said, "What are you doing here in India?" I said, "Well, I've come for 3 weeks to talk to people about death and dying and how you talk about death and dying." He said, "Oh my goodness, you're going to have a very quiet 3 weeks. We don't talk about death and dying." And he said, actually, for some, it's quite sinful. Those were his words. He said, it's a sin. And that stance was repeated in various arenas, that actually talking about death is something that's not welcome, it's difficult in India. And therefore, there's a real journey to go on for India as a country to be ready to talk about making advanced medical directives. Well, my goodness, I would say it's the same here. We've had the legislation where we can do this for many years, but we have a kind of a natural innate human death denial, which means that we don't. But I think our healthcare systems are really needing us to be more explicit as patients and future patients. So that's something that gave me a lot to think about. The other thing really is that, of course, India has a very different healthcare landscape. About 80% of patients will be seeking private healthcare. And there's a phrase in India, financial toxicity. So the financial toxicity in healthcare. And that is where families will bankrupt themselves paying for treatment. And the pain is that often it's treatment that will not bring benefit. So decision making in any family and in any, sort of around any patient is always going to be different. But one of the things that I was able to learn about was, who and where makes decisions, who makes decisions around medical decisions within families in India. And, it looks slightly different to the experience that I've personally had. So I'm coming away thinking about how do we make sure that in decision making around us in the UK and beyond, we're making sure we're asking the right questions and we've got the right people in the room. That would probably be my short summary.
Fantastic. And it rings bells with our use of mediation again in hospitals and NHS trusts, especially where we have people from overseas, people from different countries, different cultures, different perhaps medical systems. And in the UK, where we're looking at a decision around whether treatment X should be tried with this particular patient, there's a lot of discussion, a lot of weighing up and looking at whether the burden that you mentioned will outweigh the benefit. So there may be some on paper benefit for treatment X, but actually the burden is great. It may be a burden of pain. It may be all sorts of things that would actually disadvantage the patient more than it would provide a benefit. But in other countries, if you pay, you get it. And people are used to that. And when they come and buy particularly private care, a lot of NHS trusts have got a private wing, especially the more specialist child treatment centres in the UK. People come from overseas with a wad and say, well, I want to pay for this treatment to happen. And it doesn't work like that over here. In a lot of other countries, in the USA in particular, if you pay, you get the treatment, whether it's going to be burdensome or not, because you're funding it and you expect the medical practitioner to be your servant in that and actually to provide what you're paying them to provide. It's a very, very different model. And I'm hearing that, in India, if 80% of medical treatment is paid for, there'll be a similarity there, and that interesting phrase around toxicity as well. Let's just check on comments. So Vanessa's saying this is something she's greatly interested in, although in relation to loss and grief. Absolutely. There's an area of our work, by the way, which is it's not quite around decisions around death and dying or prolongation of medical treatment, but it's about when older people go into care. It probably rings bells with your work, Arabella, where mum or dad are old and need to go into care. Adult children are dispersed either around the UK or overseas. They all want to be able to come and see mum and dad in their latter years and months. Where shall we have mum and dad in care? How shall we fund it? Who shall take on this duty, that duty, the other duty? And they fall out big time. And each has their own solution. And we've done mediations, particularly during the pandemic, when we had to do online mediation mostly. We started it, but it seems to continue. It's had quite a bit of inertia, that move towards greater online. So we're doing mediation with people in different countries and in the UK around where the care of their elder family member should be provided. And it's a really, really good use of mediation. I find it's very, very helpful. There's little alternative to getting a dialogue going. What else are you going to do if you don't get a dialogue going between the family members to a particular area? I'll read Nadine's comment. It's just, sorry, after you, please, Arabella.
Well, I was just going to mention lasting powers of attorney and how family members, or a person can give lasting powers of attorney, and when those come into force, then the whole family dynamic can change, because perhaps one daughter was given health and welfare power of attorney, and her son property and financial affairs, and another child was out of the country at the time, so wasn't made an attorney. And now the decision making of, say, for example, children around an elderly parent has become fractured and complex and contentious. And the burdens of being an attorney, having those lasting powers of attorney, are quite heavy. There's a huge duty that is attached to being an attorney. And of course, in the mix of that difficult decision making, one might have anticipatory grief around the fact that the parent is getting older, or perhaps even unresolved childhood trauma or sibling issues. So I think you're right. Mediation can be a very, very valuable space in which to talk. There's a researcher, Jamie Lindsay, who's doing amazing research into medical disputes specifically, but medical health and social care. And she's asking the question, is it possible that mediation could grant us a sense of therapeutic justice? And if we look at that as not just, the judicial decision, what would a court say, but a process that is therapeutic, that allows us to resolve issues, to feel perhaps some healing, to get some greater understanding of each other, and to feel that when the decisions have been made, they've been made collaboratively, or that everyone has brought their best understanding to that process. So I think you're absolutely right. Mediation sits really well in adult social care. Yeah.
You bet. We sometimes get, because I'm a psychotherapist by background, we sometimes have specific requests for me to do work because they say, I think there's more going on in this family than meets the eye. It's not just about the surface issues. And certainly I've had cases, without giving too much away, where there are unresolved sibling issues, as you put it, going back decades, which are now being acted out in terms of supposed ostensibly decision making around the elder person's care, but actually they just want trying to get back on this person with whom they've had a grudge for decades. And it's about getting in quite deep there with the family dynamics. And what we're doing in those mediations is close on family therapy. We're careful not to go too far into that because we haven't got the boundaries set up correctly, but it's around resolving effectively what we'd call the transference. It's about things which are transferred from other disagreements into the current disagreement. And if they're not resolved, they don't go away. So these resentments that people have borne for years and decades, in some places, they're acted out in relation to this current situation around the elder person's care. So yeah, it's another fascinating field. Let's have a look at Nadine's comment, who says that not about medical issues, but from my experience in workplace conflicts and trade union movement and my experience in family courts, I found a mediator can help with transparency of what the courts will be assessing, as it can be widely different to the expectations of the parties. Fantastic point, Nadine. Yeah, absolutely. There's obviously a fine line balance, as you don't want to be seen giving legal advice, but it can really help with moving through the impasse. Yeah, absolutely. Right, hitting the nail right on the head there, Nadine, I think, and it resonates with what Arabella and I have just been talking about as well.
Yeah, I think I just add to that on about not giving legal advice. I think it's, the mediator is not there to have any view on legal matters around these interpersonal cases specifically. There's evaluative mediation, there's arbitration, but there's a duty of care that we have as mediators is to explore with parties sometimes whether they've taken enough advice, whether they're well advised. And and it can be that, for example, a trust could be encouraged to think about whether they feel that the family has has access to enough legal advice. So I think that question of, does everyone know all that they need to know, is just a very valuable part of what we bring as mediators.
You bet. And I think it's part of our ethical standing that we have to make sure that people are given advice on their rights and entitlements. And I don't want people signing an agreement where they don't feel as if they've been afforded their full rights in law, for example. And we can't insist, but we will always caveat that you need to get legal advice, and we're not going to give it. Because you lose your impartiality as soon as you advise. And for me, we may differ on this, Arabella, but I think evaluative mediation is a contradiction in terms. I think it's an oxymoron. I think as soon as you start to evaluate, I think you've lost your impartiality. But that's for another day.
Yeah.
But I want to know that people have been afforded their legal rights. And just back very briefly to the best interest cases, and when they go to court, it's often a surprise to people that Kafkas or somebody else that there will be a representative for the child, and that's sometimes a bit of a shocker for the parents. Well, we're representing the child. No, a child needs to have its own representative, somebody who will speak up for its interests in court. So.
And the same for court of protection.
And court protection as well.
The official solicitor will, in most cases, be appointed to represent P, or the person at the centre of the case.
Sure thing.
Which can be very helpful to have the official solicitor involved in the case. So it's there's value. Actually, that brings me to a really important point, that mediation can make, because of its flexibility, much more additional space for P, the person at the centre of the case, to have a voice and to be consulted than can sometimes happen within court proceedings. And that, there are bits of research on this, and I've contributed to bits of research on this, but I see this as being an area of mediation that will really grow. That if we're talking about dialogue facilitation, we've got the skills to be able to make sure that participation and access to that dialogue is as full and as rich as possible, in a way that sometimes court can be, it's difficult or intimidating. So, that's
absolutely.
why I'm a great fan of mediation.
Well, absolutely. The court process can stifle dialogue. And mediation is absolutely, antithetical to that, because it promotes the dialogue that the court might otherwise stifle, and ensures that everybody gets their voice. Absolutely. And if we're back to ethics, and that's what we're all about, isn't it? It's about the empowerment and the ensuring people have their entitlement to that voice.
And it doesn't mean that court proceedings can't go ahead. I've had various cases where mediation has not only, where the court does need to make a decision, really, around certain matters, but we've managed to narrow the issues considerably, or we've managed to broker enough understanding between parties that when a decision is made by the court, there will be enough trust and rapport for those parties to go together and deal with that decision collectively. Yeah. So sometimes people think, oh, should it be mediation or going to court, or has court failed if it continues to court? And I just don't. I think that's the wrong way of framing mediation in health and care and in workplace and employment, really. We can use mediation to make some very small changes that the court wouldn't be interested in necessarily, that will have a profound impact, particularly around arranging how parties will communicate going forward when they haven't communicated, or it's been very fractious for months or years. That is part of allowing parties to take control of the way things move forward. So we're getting a much broader definition of what mediation is, I think, as we go by.
Yeah, you bet. And yet it has to be. I think that's true. I think we're broadening always the definition of mediation, but it has to be, to my mind, based on the three cornerstones of confidentiality, impartiality, and voluntariness. And they come up often in discussion. So we've already discussed impartiality and the voluntariness today. It's always got to be there, in my opinion. And when we lose either our impartiality, because we're either advising or evaluating, when we lose the voluntariness because we're mandating mediation, then it's something other than mediation. And it's not. It's maybe a useful process, and the court is a useful process. And I think some evaluative processes are absolutely useful. Let's not call them mediation. maybe been a bit contentious in the last 2 or 3 minutes of our discussion. But they're perfectly useful process, and the kind of soft arbitration which is becoming increasingly, we're calling it civil mediation, but to my mind, it's a soft form of arbitration that's being used with courts, and that the legal profession is wanting to be more and more mandated as the years go by. Fine, it's a really useful process, and I'm sure it keeps people out of very contentious court processes, saves them a lot of fees and all the rest of it. Great, it works, buy it. It's not mediation. It's something else, but an entirely useful something else. Okay. Let's just roll back a little bit. Alid says, how did you target the NHS? Is it because you had a background, or did you solely focus your marketing to them? I think that's more for a sort of UK mediation question. I did actually have a background. I worked for the NHS for a few years. So I worked with non-speaking people, and communication aids is what I did in a clinical setting, and pivoted into working with people with life-limiting conditions, Alid, just out of interest. I worked for years with people with motor neuron disease, but in particular about how to have communication aids and how to help people to communicate when their speech is going out on them. Or did you solely focus your marketing to them? Well, I think it's the fact the NHS is the biggest employer in Europe, Alid. And I suppose 30 years ago when I was getting this started, I figured it was a big pond in which to cast my my hook. So that's how we got started there. But we've had NHS clients, the same people who've been using this for about 30 years or so. There's an AI takeaways from the meeting here in the chat box, if anybody wants to look at, including a reference for your learning from your Churchill Fellowship, apparently, Arabella. So that's interesting. Okay, so a really fascinating discussion about this specific aspect of using mediation, but let's also say you do workplace mediations, Arabella. You do workplace cases for us. You also provide more and more training for us. You've just been out doing a course for us down in London there with student disputes, that one?
That one was student disputes, yes.
Okay. And this summer, just by the way, we're making another new film. We are fated for our videos. Our videos, we've invested a lot of time and effort into these. We're making another one this summer on student relationships, as it happens. We're just getting it all lined up at the moment, getting the team sorted out, ready to do that one. So I think we're pretty well sort of in the last couple of minutes of our chat today. Unfortunately, that seems to have flown by. Fascinating area. I could talk for hours about all of this stuff. It just begs all the questions about mediation, about what we're doing, why we're doing it, where mediation is applicable, the benefits of it in relation to and vis-a-vis more formal processes like the courts, and so on. And it begs all the ethical questions in a big way. Okay, so I think we could start to wind up. If anybody else in our audience has any further comments or questions, now's your chance. We're nearly at the end of it. So where's your next trip, by the way, Arabella? Where are you off?
I'm going to Peru. Well, actually, before that, I'm going virtually to South Africa in June. And I'm due to be going to Peru in August. So
fantastic. Well, que tengas un buen viaje in Peru.
Gracias.
I hope you have a great time down there, and perhaps we can do something else when you get back and talk about lessons from there as well. That would be really fascinating.
I'd love that. Thanks for having me, Mike. It's been lovely to chat with you. Appreciate
Pleasure.
it.
Thank you for giving this time up today. So thanks very much for your delegates here as well. I'm not sure what to call you, delegates, attendees, guests. Let's call you guests. That's a nicer one. For coming along today, a large number of you today from the UK and overseas. So check out our forthcoming webinars. There's always a couple of webinars around the corner. You're very welcome to access them on the archive as well. If you check out the website, you'll find a very, very large library now of resources, including these conversations with the mediator and some Mike Talks mediation, which is me talking at you about some aspect of mediation, and a whole load of other stuff as well, including some collections of video clips that I referenced there as well. So a big thank you to you, Arabella. Thanks very much to all of our guests for coming along and contributing as well. We'll see you all next time on another of our webinars, and that's bye for now.